First of all, you need to watch your language, okay?
All right, now, because it's not fair for me. I want to go home, bro. I had one fight. I had 2 fights, and y'all giving me 18. Y'all giving me 15 months for that.
Mr. Lewis, I told you, do not speak. I expect that you would listen.
She's lying all the time now.
On 5 separate occasions, a judge has found Mr. Lewis to be a danger to himself or others, hence his involuntary placements to Connecticut Valley Hospital and or Whiting. Obviously, the judge knew what they were doing because each time he has created new victims upon his release.
And I couldn't find a more prudent time to bring up this case in the wake of Irina Zarutska, who was murdered by Brown on the train. Brown, who has a similar story to this man in the state of Connecticut, this man's revocation hearing that we are about to see. You see, like Brown, this man was also signed by a judge to go to a medical institution after being released from parole. And like Brown's case, did not go. As well, like Brown, he was kicked out of his own home by his own family relatives, saying he needs medical help. And like Brown, he didn't receive it. Yet each time after getting out from parole, he creates new victims. We are about to watch the parole revocation journey that spans over a year for a man that we can see escalates in violence day by day, becomes more dangerous with each time that he is released. He is a ticking time bomb. He is everything that is wrong with this system. And it's not just him who is at fault, but it is the DOC, it is the judges, it is the system put in place to protect us. Now let's take a step back and watch his parole revocation journey.
You solemnly swear solemnly affirm as the case may be, the evidence you shall give in this case should be the truth, the whole truth, and nothing but the truth, so help you God, about penalty of perjury?
Yes.
All right, so would you like to make any statements at this time?
Just a brief statement. We just want to sum up briefly Mr. Lewis's time on special parole supervision. This is his 3rd violation under this term. In 2021, he violated criminally after seriously assaulting 3 individuals at Connecticut Valley Hospital, one of which was a psychiatrist. On release from that violation, he was placed again at a state psychiatric hospital, was discharged on July 17th, and effectively absconded from supervision 4 days after, on July 21st. Most recently, he served a 6-month sanction and was re-released back to a state psychiatric inpatient facility. This time, he discharged from that hospital and completely disregarded his parole conditions within 4 hours of release. Mr. Lewis cut off his GPS unit, absconded essentially from his only parole-approved residence, and was found in Groton at 2 a.m., 2 days after his escape, walking on the side of the road in the dark, not dressed appropriately for the weather at the time. It is our understanding that Mr. Lewis had a probate court hearing. However, we are asking that probable cause be found, and we discuss any of the placement of that decree at his revocation hearing.
Thank you. At this time, defense will have an opportunity to speak at this time, if you'd like to say.
We're not necessarily contesting the charges. What I am contesting is the seriousness of the charges here. The second prong. Clearly, this individual, and none of us here have a medical degree. There was a hearing in court, which I was not aware of until I spoke to my client, because this notice of the hearing, even though I have an appearance filed for the preliminary hearing, I represent Mr. Lewis. I was not notified regarding this court order from probate court. Apparently, he was given civil representation, but there's a list of name and addresses on who this notice was sent to, and my name is not on this list. So after speaking to my client, I was able to obtain this document. and it indicates that a probate judge on April 22nd, 2024 has ordered Mr. Lewis to be put at the forensic facility at Whiting, which I think is the appropriate location for Mr. Lewis. If that being said, if he is placed there, he's not at liberty, he's not out in the community. After receiving this document, I did verify, I did speak to Michael Suso yesterday. He made some phone calls to, I believe he's a supervisor now, Mika Man, who had dealings with the mental health clients I previously represented. They do have a bed available for Mr. Lewis. As far as the date that it's available, Mr. Suso was not able to procure that date for me. He was hoping to get back to me prior to this hearing, and Mr. Suso was aware of, I think he has a copy of the document. He knows the hearing was at 10:45 this morning, I also indicated to Mr. Suso, the reason why I reached out to him, our unit has been in existence for almost 5 years. We've never had a situation where there was an order from probate court that a client be placed at a psychiatric hospital, and there is an order in place. Bed is available, just don't know when the date is available. So I am asking you, I have no issue with the finding of probable cause, but my opinion, I'm not a medical doctor. Mr. Lewis needs to be in a hospital setting, not at the Department of Corrections. I don't think, there's no way he'd be receiving the same treatment and services as per the order of the probate court to place him at Whiting. Once again, and I had a discussion with Mr. Suso yesterday, he is not at liberty if he's placed at Whiting Forensic. So we want to make sure there's a distinction, get him out of DOC to put him at Whiting. He's not at liberty, at Whiting Forensics.
Okay.
And just, I'm sorry, just to add, I was hoping to hear from Michael this morning. Unfortunately, it didn't happen by 10:45, but I was also indicated he did have conversations with Mika Man to verify that there was a bed available.
Okay, thank you.
May I respond to that, or?
Sure, go ahead.
Yeah, so I just want to say that PCS is certainly not contesting the decree put in place by the probate judge. But as the attorney mentioned, we have no idea of bed availability as of today. If it, you know what I'm saying, if you determine that it's not serious enough, and that decree is not a same-day admission ticket, as far as we're concerned, nobody from the Department of Mental Health has come up to meet with Mr. Lewis to determine the appropriate hospital setting. Whiting obviously is very restrictive. It's a maximum security facility. He may not require that when DMS evaluates him, and we don't know lower level security hospitals that may be available today.
Okay.
Hey, may I just add to that? I'm not disputing what you're saying about the placement of the bed, but according to the notice I have here, there was 2 sworn certificates of 2 physicians who testified at the hearing, and they're the ones that made the recommendation to Whiting Forensic.
So what I'm going to do next, I'm going to announce my findings based on evidence and testimony that I have heard today. I will note that the offender, as previously stated, does have 2 prior violations of criminally absconding with a 6-month sanction received in 2023 for that last absconding violation. He's only in duty for a little over a month prior to being returned to custody. I am going to make a final probable cause on charge 1, police direction GPS, based on the evidence provided, exhibits I, J, and K. I make a finding probable cause on charge 2, police direction curfew, based on the evidence provided, exhibits I, J, and K. Charge 3, release direction residents that make a no finding probable cause based on the charge not meeting the elements. There's no evidence that he intended not to return or was moved to another residence. On charge 4, I do make a finding probable cause, release direction absconder based on the evidence presented in support of the violation. It's M, J, and N. As is evident, the offender cut his GPS bracelet off with shows his intent to avoid parole supervision. So I do find the act is serious enough to warrant revocation. In terms, you should be detained while you wait for your revocation hearing. So we're going to schedule you for another hearing, sir, and then we're going to determine where we're going to work with you for your next plan of where your housing is going to be and what kind of services you'll be able to get, okay? So we're gonna bring you back soon.
You know how long I'll be?
Has to be within 60 business days
Mhm.
because you don't have any pending criminal charges. Once we get a date, I'll set up a call with you. I'll explain the next step to you. But they are on a time frame to take care of this for you, okay?
I'm going to the hospital.
Well, that's.
We're looking to put you in that direction, sir. We're just trying to figure out, the best route for you.
Why 60 days? That's like 2 months.
It can be up to that amount of time. It can be sooner as well. Okay, I just don't have a date until I look at my calendar. So when I look at my calendar, you'll be notified, your attorney will know, what date we're gonna move forward for. Okay, so you're all set for
I'll be back
today.
in touch with you, Mr. Lewin.
Huh?
I'll set up a call with you once I get a date. I'm gonna speak to you again.
Can you make it a little bit early, please? Because I'm trying to get out of here.
We're gonna talk about it. You're all set for today, sir. Thank you, T.O. Richardson.
Thank you.
Thank you so much.
Now, it ends up being a month and 2 weeks and a couple of days, and he's back for this next hearing. We're about to watch it, and then we're going to see more hearings from this man. But I want to let you know a few things before we jump into this hearing, just so we can kind of keep touch of what's going on here. This is the record that we have dating back. So Connecticut only shares 10 years worth of records. So as 125-2015, which it is the earliest available records, we can see as his arrests and as they progress to increase violence, right? Interference with an officer on 125-2015, 410 is criminal trespassing, 5/28/2015 larceny 6. Again, these are smallish crimes. 9/27/2015 larceny 6. He keeps getting sentenced to jails, right? And he gets suspended sentences. We see this all the time. It's just a bunch of gimmicks, right? No one's actually spending time in prison. 1/28/2016 criminal trespassing. Again, they suspend the sentence. Why? I don't know. I mean, he's backing up so many years, but this is the light on crime attitude that we're accustomed to in many different states, as probably on the East Coast, right? 4/1/2016 criminal trespassing, 7/20/2016 criminal trespassing. Then we start to get a little more violent. 12/2/2016 robbery, second with a weapon. He gets 3 years jail, special parole, 7 years. He's obviously doesn't serve the 3 years jail because on 8/23/2019 he has an escape, which would have been, escape, I guess, from this parole. He got sentenced there for 1 year jail, suspended. Again, all a bunch of gimmicks, right? Because how do you keep getting suspended sentences? Then 2/5/2021, so 2 years after this escape, he has an assault third degree where he's sentenced to 11 months jail, which makes no sense. I mean, he's backing all this suspended time. He has 7 years special parole. Why is he not serving all of that time? Arrested on 2/5/2021, which means that even though you would think he should have been backing his time here, he's out unless this assault was when he assaulted people in the hospital. That's possible. The one they were just talking about. And there you have it. I mean, again, it's the escalating violence and assaulting medical staff. But here he is. We're going to watch the next hearing, part of this process. And as we'll see, it really, well, let's just go. Let's jump in.
Today is June 24th, 2024. At this time, the state will have an opportunity to speak to any evidence at this time. If you could just please raise your right hand, I'm just going to swear you in under oath. You solemnly swear, as I'm still affirm, as the case may be, the evidence shall give in this case should be the truth, the whole truth, and nothing but the truth to help you God from penalty of perjury.
Yes.
So would you like to say anything at this time?
Sure. I'd just like to reiterate what we spoke about in the preliminary hearing, that Mr. Lewis has shown a pattern of completely disregarding his parole conditions. This is his third violation of his special parole. The first was a criminal violation where he assaulted 3 people at CVH. The second was last summer when he absconded from parole supervision. And then the violation that brings us here today, where he was in the community for a mere 4 hours. before he cut his GPS unit off and attempted to evade parole supervision. I would like to note that Mr. Lewis did have a commitment hearing, and he has a judge has agreed to commit him to the Connecticut State Hospital System. We would just ask him, we are agreeing to that. I think that is what Mr. Lewis needs. We would just ask for a period of time, as we are in the planning stages right now with Whiting Forensic Hospital, as well as Garner, on finding a date for him to go.
Okay, thank you. I'd like to turn it over now.
Yes, my comments are brief. We did have a preliminary hearing. I agree with 90% of what P.O. Richardson said, but I don't agree with, he's been in since April 7th. And at the preliminary hearing, we did have a order from the probate judge from the date of the hearing to April 22nd, 2024. And I did make my pitch on that date unsuccessfully, that there was a bed available for him there. I spoke to Michael Sousa on Friday, and he did Friday, June 21st at 9:13 a.m. There is a bed available now. We just need parole. The Board of Pardons and Parole needs to agree to send them there. But Mr. Michael Sousa indicated to me that the bed is available. And as I indicated, I forwarded an email to the hearing examiner. Upon his parole revocation hearing, there's inpatient state psychiatric at Whiting Forensic for Mr. Lewis. So I am asking to have my client go to that bed at Whiting Forensic. As P.O. Richardson said, I think that's probably the best location for him. I understand there's been a couple of previous violations, but I think he needs the psychiatric treatment that desperately, in my opinion. But he is currently on his medication. I did speak to my client last week, and I want to be heard a little bit about his background at the appropriate time.
Okay. So what I'm doing
Can I
next.
respond to that, or?
Sure, go ahead.
No, I mean, I do agree. I think that this is a more arduous process than just having an open bed. Medications need to be ordered. The receiving psychiatric facility needs to be sent proper documentation. Transportation needs to be set up. I don't think we need to delay this very long, but I think that there are many things in place, or there's much planning to be done, that it would not be reasonable to do today. So there may be a vet available, but the amount of paperwork that needs to be done and the amount of medications that need to be ordered, it is more than what needs to be done today.
I don't mean to be disrespectful, okay? Please, I'm gonna start with that. Why wasn't the ball put in motion from the last hearing if there was already a court order from April 10th? It's June 24th. Why are we waiting 3 months to have the ball put in motion? If you know the answer to that, it might not be part of your job or what you do, but the guy's been sitting for 3 months already. If you can see from my standpoint, why would things put in motion? So I spoke to Sousa prior to the preliminary hearing, and he told me there was a bed back on May 7th, when we did the hearing. Back then, I argued unsuccessfully, obviously. That's why my client is still incarcerated. Why on June 24th, we're saying now that we need to do paper? Why? If you know, it might not be what you do.
Yeah, I mean, that's not a function of my responsibilities in this, but I appreciate. But I do know that there are at least 4 separate state agencies that are involved with transferring someone from the custody of the Department of Corrections to the custody of Whiting Forensic.
Okay, thank you.
Yep.
All right, so what I'm going to announce my findings. So on charge 1, I do find you violated condition GPS. This is based on the evidence that was provided. If it was I, J, and R. On charge 2, I do find you violated condition curfew. This is based on the evidence that was provided, I, J, and K. As I previously stated, charge 3 residence was not taken into consideration, as no finding was made at the time of the preliminary hearing. On charge 4, I do find you violated condition restriction absconder based on evidence provided, M, J, and N. So that's the fact finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, council will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So I don't know, Pierre Richard, if you have anything else you'd like to state at this time before I make a recommendation?
No, thank you.
Okay, defense?
No, I'm just asking that my client obviously be sent to that bed as soon as possible with the understanding of what P.O. Richardson put on her record. And I've been with the state system for 25 plus years. So I know the difficulty of transferring someone from DOC to Whiting Forensic. I'm just a little, once again, I don't mean disrespect, a little frustrated that, he's been in since April 7th. We had the hearing on May 7th, and we're, things need to put in motion. My understanding, like I said, I spoke to Sue Saw yesterday. There is a bed available with the understanding we need a little bit of a transition period. My client, he's 33 years old. He is obviously on disability. It's indicated to us he did complete the 11th grade at ACES Whitney Academy in Hamden. And he received services from CVH, Middletown, and Capital Region Mental Health in Hartford. After speaking to him last week, I do believe they have him on the correct medication. I was able to have a conversation with my client. He would like to finish school, obtain his GED. He's interested in attending culinary school. He's amenable to part-time work. He has an uncle who owns a Jamaican restaurant in Hartford. He thinks he might be able to get some part-time work there. And obviously he needs to reestablish clinical services with Capital Region Mental Health Center once he completes his treatment at the Whiting's Forensic. So I am asking to have him reinstated back to the bed at the hospital as soon as possible. Thank you.
Thank you. So I've listened to testimony today. I've read all the evidence. As was previously stated, since the offender's third violation, he's a past criminal and absconding violation. He is taking his medication now. He was not in the community for very long before coming back. And he does have a bed available at Whiting. So based on the information that I have, I am going to recommend that parole be revoked and that he be reparoled for August 7th of 2024. It's about a 4-month period of confinement as a sanction. Hopefully there should be plenty enough time to get him settled into transferring to Whiting. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, no contact with victim GHOB, MB, and general contact in New Britain, as well as mental health treatment. My findings go to the board on July 5th. At that time, the board's going to make the decision. The board can let him out sooner if they like. They can also hold him in longer. But it is recommended that he be transferred on 8/7 in that plan that hopefully is developed by then for him to transfer over there.
So Marlon, do you understand if the board adopts the recommendation on August 7th, you'll be going to the hospital, providing the board adopts the recommendation. Do you understand that, Marlon?
Why so long?
I'm sorry?
Why so long?
Why so long?
They're gonna get a plan for you to transfer you to make sure that your transition is the best that they can make for you. Okay, they want to make sure you have all the stuff you need.
Okay.
Okay, so they're gonna help you out.
Thank you. Thank you, P.O. Richardson.
Thank you guys so much.
Can it be sooner than that?
If the board wants to on July 5th, they can. You and I will get something in writing after that hearing on July 5th. It could potentially be sooner, but you have to wait for the final paperwork.
Would that bed still available?
I'm sorry?
Would that bed still available?
Yeah, the bed's going to be still available whenever the board says you can go.
All right.
All right.
Have a good day.
Yeah.
Thank you, P.O. Richardson.
Okay, thank you so much. You both have a good day.
You too.
And the board accepted that recommendation. So he was sent out to the hospital once they got all their ducks lined up in a row. I mean, apparently it takes 4 separate state agencies to move somebody who's been committed by a judge to this type of mental hospital. But frankly, I don't understand what it's doing for him. We already seen that he assaulted 3 people in the hospital before. What's going to stop him from going to that hospital and assaulting more people? And for a moment, you can't say, oh, properly medicated. He went out of a prison where he was being properly prescribed and cut off his ankle monitor within 2 hours. So I don't buy any of it. I just think this is a clear case where someone needs to be in prison to prevent future victims. But anyways, let's go jump into his next hearing, because guess who's back?
What's up?
Good morning, Mr. Lewis.
How you doing?
Good. Attorney Jones, would you like to talk to him for a second?
Yes, thank you. Can you hear me?
Yeah.
Okay, thank you. Mr. Lewis, it's unclear if you want to have representation by the Public Defender's Office. I'm from the Public Defender's Office, so if you want representation, we would need a continuance so that we can take your application. Can you just let us know what you want to do?
Yeah,
So do you want an
You do-
attorney or do you want to, yes, okay.
yeah.
So,
Okay. Do you understand that you will need a continuance then so that we can take your public defender application and determine your eligibility for
Never mind. If I
services?
gotta get a continuance, never mind.
okay, so you want to
Okay,
proceed without an attorney then today?
Yeah.
Okay. All right, thank you, Attorney Jones.
All right, thank you.
All right, Peel Goodman, you can hear me, right?
Yes, ma'am.
Awesome, okay. All right, Lewis, then we're gonna get started with your preliminary hearing, okay? Good morning, I am Peel Meisinger, hearing examiner for the Board of Pardons and Paroles, the preliminary hearing, concerning Lewis Marlin, number 379405. Today is November 12th, 2024. This hearing is being conducted via video at the BOPP Central Office in Garner Correctional Institution. This is a public hearing. Public access. This hearing is available via video live stream. Could you please take me your full name and DOC inmate number for the record, sir?
Marlon B. Lewis, 379405.
Thank you. And you have a parole officer present today. Please identify yourself.
Yeah,
Parole Officer Kimberly Goodman.
Thank you. This is a preliminary hearing, which is the purpose under Connecticut law. It's to determine if there's probable cause to believe you committed an act that violated the conditions of your parole, determine if the act is sufficient years to warrant revocation of your parole, and to determine you should be held in prison pending further proceedings. The state, not you, has a responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is release you and place you back on parole supervision. If I find probable cause and determine the act is sufficient years to warrant revocation, you may be held in prison pending further proceedings. You should know preliminary hearings are a burst seal proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So first, I'm going to read you your rights, and then we're going to review the parole violation charge that the state appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue probable cause in the of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure right now?
huh?
Do you have any questions about the procedure right now?
When I'm being charged with.
Well, we're going to get there, but so we're going to keep going, okay? So you have important rights today, the right to have an attorney. Do you want to continue without counsel? You stated?
Yeah.
Okay. You have a right to receive the written notice, charges of violations. You received the written notice.
Yeah.
You have a right to view the evidence against you. You have a right to submit evidence to support your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine reverse witnesses. Do you understand these rights and are you ready to move forward?
Yeah.
All right, so now review the charge of the state appeal is bringing against you and the information underlying each charge. Appeal Goodman, please read the charges.
Charge 1, under residence on 10/24/24, you were remanded from Whiting Forensic Hospital for threatening and violent behavior towards staff and other residents. Because of your behavior, staff requested your removal as you were no longer allowed to reside at 70 Middletown, Connecticut. This was your only approved parole residence. You were in violation of your condition of parole, release direction, residence. Charge 2, obey all laws. Under A, obedience to the law. On 10/23/24, you made threats to assault Whiting forensic staff on Unit 6. You entered another patient's room unprovoked and physically assaulted them. While the patient was lying in his bed, you jumped on top of him and punched him multiple times in the face and the head. You were restrained as you presented an imminent risk. You continued to make threats of assault on staff and you spit on the doctor. You had to be moved to another unit. Your behavior meets the threshold of CGS 53A-60, assault second. On 10/24/24, you became agitated and attempted to assault staff on Unit 4. You threatened to stab staff with a spoon. You had to be restrained. You were combative. You bit the inside of your mouth and spit blood at staff. Your behavior meets the threshold of Connecticut General Statute 53A 181, breach of peace in the second. Based on your behavior, you're in violation of special parole. Condition number 2, obey all laws. Additional condition, mental health treatment. On 10/24/24, you were remanded from Whiting Forensic Hospital per the request of Whiting staff for threatening and assaultive behavior. Because of your removal for such behavior, you were unsuccessfully discharged from your mental health treatment program. You were in violation of your condition of parole. Additional condition, mental health treatment.
Thank you. And the state has filed the following exhibits that are pre-marked for identification purposes. As Exhibit A, signed parole conditions. B, remand actual custody order. C, notice of parole violation, parole rights. D, parole violation report. E, Whiting Forensic Hospital integrated progress notes. F is misconduct report. G, DOC disciplinary report. H, email from Dr. Berger. I, documented conversation between PS Mann and Dr. Berger. J, demis police case incident report. K, email from Lieutenant Driscoll, RE assault. L is assault second description. M is breach of peace second description. And Exhibit N is revocation hearing summaries. Exhibits A through N are repeated. Those are the same ones listed in A through N previously stated. And O is misconduct report, and P is probate involuntary commitment degree. Did you receive notice of parole violation report, and the other documents I marked, sir? And did you review them?
The what?
Did you review the information that I just stated?
Not really.
You have it all? Okay, so do you want to continue still? Bless you. God bless you. So do you want to continue? Do you want to continue with the hearing?
Yes, please. Yes, please.
Okay, so we have no witnesses today. So at this time, the state will have an opportunity to make a short statement, testify with respect to probable cause and severity of the allegations. Theo Goodman and Mr. Lewis, I'm going to swear you both in so you can both speak today. Please raise your right hand for me. You solemnly swear or solemnly affirm as the case may be, the evidence you shall give to this case, be the truth, the whole truth, and nothing but the truth to help you God without penalty of perjury?
Yeah.
Okay.
I do.
So Theo Goodman, would you like to say anything at this time?
Just a couple words. This will be, if it moves forward, Mr. Lewis's 5th parole violation. It should be of note, I think, that the charges speak for themselves in terms of this period of supervision. But this will also be the 4th time that a court found him a danger to self and others and gravely disabled, so much so that they had to involuntarily commit him on 4 occasions to Connecticut Valley Hospital and Whiting Forensic Hospital. And I think that's an important piece of an important piece for the board to be aware that he's not just placed in mental health programming, he's court ordered into that programming because he poses such a significant risk to others. And that's all I have to say related currently to the charges.
Right. So this is the only time you get to speak. Do you want to say anything else?
My apologies. I didn't realize I could do any more at this time. I mean, we've been trying to attempt to work with Mr. Lewis since I believe 2019. Hang on, I just want to check. I don't want to put something on the record.
It's December of 2019 is when he started.
Yeah. So since December of 2019, he's escaped, gotten new charges for escape. He has absconded twice after being released from a secured setting. He doesn't abscond from those secure settings. He absconds when he's finished in those secure settings. And he was remanded from Connecticut Valley Hospital for previously assaultive behavior, for which he received new criminal charges, and then had to be remanded again for assaultive behavior. And there could be potentially, I don't know, criminal charges coming forward related to the incidents that just recently occurred at Whiting. So we're recommending at this point a revocation to be reviewed as per outlined in your directives. We just don't have anywhere we can safely place Mr. Lewis. And even when we place him in the most secure, safe environment, he threatens, bullies, and assaults people who are more vulnerable than he is. At those places, those programs, he's a big fish in a little pond. But when confined in DOC, he's a little fish in a big pond. And I don't know how much more PCS can do in terms of keeping the community safe and have Mr. Lewis on supervision. We've tried every setting imaginable. And I want to make it very clear, and I had documented in this case, as well as in previous cases, that he's been evaluated in each of the situations in which violence occurred, and it wasn't, the violence didn't occur as a result of mental illness, as a result of anxiety, depression, psychosis, and that's documented in the contact notes from Dr. Berger for this assaultive behavior, but it's also documented in the revocation summaries from the previous assaultive behavior at Connecticut Valley Hospital that those the violence is for secondary gain and is not a result of mental illness.
Thank you. So it is now, Ms. Lewis, your opportunity to respond to the parole violation charged against you. However, remember that you may remain silent. Would you like to say anything at this time?
Yeah.
Go ahead.
When I went to Whiting, they was giving me different medication, and they gave me Depakote and some other medication, and I have a side effect. That's the same Depakote I had when I had the other assault with the older lead guy. And they was doping me up with a lot of Depakote and stuff like that. So I was going through it. I keep on hearing things, feeling strange, can't sleep. I was telling the doctor, why you giving me Depakote? I'm allergic to it. So they would just keep on giving it to me. They said, you just gotta take your medication. That's the only way to get discharged. I'm like, wow, that's crazy because I'm taking this Depakote, I'm allergic to it. It's in my profile. I already read through it. When y'all give me the injury report, I already read through it. It says, Marlon Lewis is allergic to Depakote and Risperdal. That's what it says, and they keep on giving me the same medication. And I came to this jail, they stopped giving me Depakote. So why is they doping me up with a lot of medication? Probably that's the reason why I'm getting. That's probably the reason why that's why I'm getting into
Mr. Lewis, do you want to say anything in regards to the charge?
That's why I went so crazy. So I don't know why she's saying that Mr. Berger was saying that it's not because of my mental health. It is my mental health because they was not giving me my privacy. They was making me feel like I'm an animal in there. And I was in there with people that have charges like murder charges and all that. I don't know why the hell out there put me in Whiting for when y'all know it's a prison. It's a prison still, and I'm meant to be free. I'm meant to be free, you know what I mean? So y'all put me in Whiting in a prison hospital where people have murder, people have sex offenders, all of that stuff in there, and I feel nervous and y'all doping me up with medication. Of course I'm gonna get into a fight. If somebody says something smart to me, I'm getting into a fight. So the guy said something smart to me and I got into a fight. He was like, what are you looking at? Why you looking at me for? So what you want me to do? Just turn my face, turn my cheeks the other way? No. I'm doped up with this medication, bro.
Okay. All right. So I've noted what you said, and I've noted what the parole officer said. I will.
You can't even review it that I'm allergic to Depakote from
Okay. Well, I noted that, sir. I noted what you said, so I have that.
You know I'm allergic to Depakote?
No, I noted what you just said on the record. I took notes on what you said in the parole officer. Okay. So that's all I'm saying.
Can you find out I'm allergic to Depakote?
I don't do that. That's not my job.
All right.
So I've listened to your statements. I've listened to the parole officer's statements. I will put on the record that you do have 3 prior criminal violations. So this is your 4th parole violation on this period of parole supervision. You do have a history of escaping and absconding that was noted. And you were only at the facility for, looks like, a little over maybe 2.5 months before you came back. So based on this information, based on information that I have received from the state as well as testimony today, I'm going to announce my findings. So on that charge 1 condition, residents, I'm making no finding probable cause based on the charge not meeting the elements of residence. On charge 2, I do make a finding of probable cause, obey all laws, obedience to the law, based on the evidence and testimony presented in support of the violation, which is exhibits EJKL on part 1 and E&M on part 2. And I make a finding of probable cause on charge 3 condition, additional condition mental health treatment, based on the evidence and testimony presented in support of the violation, which is exhibits EH, I, and P. So I do find the acts of serious enough to warrant revocation. That attorney should be detained while you wait for your rev hearing. So at the rev hearing, myself or another hearing examiner will determine if you violated conditions of your parole. If so, the hearing examiner would make recommendations regarding whether your parole should be revoked, what any sanctions should be imposed. So we're going to bring you back, sir. We're going to have your revocation hearing, and then we're going to determine what's going to happen moving forward. Okay?
You know what day it is?
Not yet, but it has to be within 60 business days of your return to custody. So it will be from, you came in 10/24, so it'll be within 60 days of that. Okay, so you'll be notified. We'll let you know. So you're all set for today, sir. We'll see you soon.
All right.
Thank you, Peel Goodman.
Thank you, ma'am. Have a good day.
Have a good day.
Happy holidays if I don't see you.
You too.
Thanks.
You know, his PO officer said it best, big fish in a little pond. He likes being in the hospital because he gets to be the bully. He gets to be the monster. And as you can see, it didn't take long at all for him to create new victims. And this is just maddening to see this. We get to now see the inside, the inner workings of the system and just how it's possible that this can happen. And who would have thought? Who would have thought that he would go back and assault people again? It's not just the patients that he's assaulting, but he's assaulting the doctors and the staff and spitting blood. It's just disgusting. And what do? It's just little reprimand after little reprimand, even while he has pending felony charges against him. And it is just utterly disgusting. And this man, he knows what he's doing. He's smart. He knows how to play the system. He's been playing it his entire life and he's loving it. But you know what? We're back. It was just about 6 weeks later, less than the 2 months. Who would have thought he's in a red jumpsuit? I could never have predicted that. Let's see what the parole board does again. And again, I think that this just brings tremendous insight into what we're dealing with, into what we just saw happen with Brown murdering an innocent woman on a train. And you say, how is it possible that he's out, that he's not locked up? Well, this, I think brings some clarity into how broken the system is. Let's jump in.
Good morning, Mr. Lewis.
Hi, how you doing?
Doing all right. How are you doing?
I'm doing good.
Okay, so we're going to start your revocation hearing, okay? I have your attorney here, okay?
Can I talk first before you started?
Before?
Yeah, can I talk? Can I say some few things?
Regarding what, Marlon? Is this about this case?
Just let me talk. It's about this case. Let me talk.
Well,
Am I
you're going to have a chance to talk at a certain point. I have to get started though. So,
because y'all just let me do a lot of time for some bullshit I did. You know what I mean? Y'all give me a lot of time.
Marlon.
I like that shit, bro.
All right, are you gonna hear me out here? You gonna listen to me or you're not gonna listen to me?
I'm here. I hear you out, but I'm just saying you're giving me a lot of fucking time for this shit, bro.
First of all, you need to watch your language, okay?
All right, then, because it's not fair for me. I want to go home, bro. I had one fight. I had 2 fights, and y'all giving me 15 months for that. 15 months.
Can we start the hearing?
That
we
wasn't
can
even my
follow through?
fault. They hit me first. I
Louis.
was defending myself.
Louis, you need to stop talking because I
I
need to
was
start the
defending
hearing.
myself.
This is not your time to talk. I'll let you know when it's your time to talk. We're gonna get started right now. So good morning, I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles Revocation Hearing, St. Louis, Marlin, number 379405. Today is May 13, 2025. This hearing is being conducted via video at the BOPP Central Office in Garner Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number, sir?
I don't feel like to do that.
I do it for him. Marlon Lewis, 379405.
Thank you. And we have a parole officer present. Please identify yourself.
A parole officer, Kimberly Goodman from the Parole and Community Services Mental Health Unit.
We have counsel here. Please identify.
Attorney Alfonso Sirico, public defender with the Parole Revocation Unit on behalf of Mr. Lewis.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review, make findings of fact with each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation or one or more conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'll read you your rights, then we're going to review the parole violation charge, state your parole officer is bringing against you. I will review and identify this filed for the record. The state will have an opportunity to present relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. You have important rights today. The right to have an attorney present. You have counsel here. You've right to receive the written notice of charges violation. You received the written notice. Okay. You have the right to review the evidence. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses or cross-examine diverse witnesses. You understand these rights and are you ready to move forward?
Yeah.
Okay. So we'll now review the charge. State your parole officer is bringing against you, any information underlying each charge. So, P.O. Goodman, please read the charge.
Do I need to be sworn in?
Not to read the charge.
Oh, okay.
I will swear you in though. I'll swear both of you in just in the event that you do speak. I'll just do
My
it now.
apologies.
No, it's okay. Just raise your right hand for me, please. Who's gonna raise your right hand? All right. You don't have to speak today. You solemnly swear, sincerely affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth to help you go out upon penalty of perjury?
I do.
All right, go ahead.
Charge
Yeah, I be
one.
telling the truth, but y'all be telling lies.
Marlon,
I said you're not allowed to speak
you're
right
not
now.
speaking today.
It doesn't matter, bro. It's not right. Y'all telling lies.
Go ahead, P.O. Goodman.
The charge under obey all laws, obedience to the law. On 10/22/24, while a resident at Whiting Forensic Hospital, you were involved in a physical altercation with another resident. You are seen on video footage punching the resident in the face and head, and the patient fell to the ground. You are then observed punching and kicking the resident in the face and head while he was lying on the ground. The patient wished to press charges. Upon full investigation by the Demas police, the police found probable cause existed and applied for an arrest warrant. On 11/27/24, Judge Fano signed a warrant for your arrest on the charge of assault second, at which time probable cause was established. On 12/18/24, you were arraigned at Middletown Superior Court under docket number M09M CR 24-024-8991-S on 53A-60A7 assault second, at which time probable cause was upheld. Because of your behavior, you are in violation of special parole condition number 2, obey all law, obedience to the law.
Thank you. In the state is filed upon exhibits pre-marked for identification purposes. Exhibit A, signed parole conditions. B, remand after custody order. C, notice of parole violation. D, parole violation report. E, disciplinary report, revocation summary. F, assault second description. G, Whiting Forensic Hospital interview progress note. H, documented conversation between PS Man and Dr. Berger. I, Department of Mental Health Addiction Services, Public Safety Division, Police Case Incident Report. A, State of Connecticut arrest warrant application. K, application and habeas corpus. L, continuous met. M, judicial grants pending, and N is involuntary commitment to probate decree. Defender received the parole violation report, and the other documents that I just marked. Did you
Yes,
review them?
I have all of that.
Okay, and council has filed the following exhibit pre-marked for identification. Expense exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence? We don't have any witnesses. I will put on the record, I received the addendum from PCS. The addendum reported March 27, 2025. Offender was convicted of assault third to 9-month jail sentence. The EOS date on that is 9/18/25. The PED is 8/7/25 on that new conviction. So at this time, the state will have an opportunity, if you'd like to present evidence, and speak to any of the evidence submitted at this time. So if you'd like to appeal, Goodman.
Not at this time. I'm gonna hold speaking until afterwards. I think I currently think the charges speak for themselves. And the
Okay.
evidence as well.
Thank you. So I'll
Thank
turn it
you.
over to
Yes.
defense.
Yes, just briefly regarding the charge, I do have the same information, and it was the charge, the misdemeanor assault 3 with the 9-month sentence. P.O. Goodman, just a couple quick questions here, just to clarify the record here. So the parole violation report I have here with this current charge of obedience to the law, the incident date is October 22nd of 2024, correct?
I believe that's correct. I'd have
Okay,
to.
that's what I have in front of me. So the Commissioner of the Superior Court put on the record, it's October 22nd. And you were his previous parole officer where a hearing was conducted with Attorney Robert Famiglietti in the past. You remember that?
Yes.
Okay, and my client was given a 14-month sanction for that violation.
That give me 15 months. That give me 15 months.
Okay, Marlon, it's not your turn to
That give me
speak right
15
now.
months. That wasn't 14 months, it was 15 months.
Okay, it's not your turn to speak right now. You're gonna keep interrupting me, we're gonna have you removed from the room.
Well, stop lying.
I'm not lying, you should just sit there and let me do my job, okay? I'm trying to help
Do
you.
your job right.
I'm trying, but you keep interrupting me. So what I want to put on the record, P.L. Goodman, the incident, the previous incident where he was represented by Attorney Famiglietti, the incident date on that was October 23rd of 2024. So Mr. Lewis was processed on an incident that happened the day after this particular incident. I'm not making any claim that it's the same incident. They're 2 different dates, but he was, so I'm not sure. I know you don't have anything to do with that, and neither do I. That warrant was there somewhere, obviously, as it happened previous to his other violation. Do you agree with that, I hope?
I'm not sure I understand the questions. Can you say that again?
The question is, let me rephrase the question.
Yep.
This incident here occurred prior to the other incident date where he received the 14-month sanction, correct?
I believe that that's the case. However, the warrant wasn't issued until November.
Correct.
So there was no probable cause established at the time of the other incident where he received it was either 14 or 15 months. I can't off the top of my head.
Correct. But I guess just to clarify, right, this incident, I understand the warrant came out in November. It predates what my client was in front of the hearing examiner with Attorney Famiglietti's hearing, correct?
I believe that's accurate, but again, I don't have the other violation report in front of me.
Right. I'm just going to put on the record. I did obviously pull the old file to prepare for this hearing. The other incident date is after this date. Okay. I just want to make sure it's clear record because he was never obviously released into the community from that sanction, and it's just the old warrant that came out, and it was as P.O. Goodman indicated, it was not served until November. Where it was, I have no idea. Could have been on the judge's desk, could have been a prosecutor, been on a police officer's desk. I have no idea. But that warrant came out after the other incident date. It's not a new. He was never released, obviously, into the community. That's why I wanted to make sure the record is clear.
Okay, thank you. So what I'm gonna do next is announce my finding. So on that charge one, if you find you violated Obey laws, obedience of law based on your conviction of assault third, receive a 9-month jail sentence. That includes the fact-finding portion of the hearing. Before I make recommendation, the state will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So P.O. Goodman, would you like to say anything at this time?
I would, thank you so much. The state, we just would like to say this is going to be Mr. Lewis's 6th violation. It'll be his 3rd criminal, and he's had 3 technicals. The criminal violations have all been for violence, for assault. State would like to put on the record that Mr. Lewis is currently in restrictive housing or SEG as a result of an assault that happened on Sunday.
I didn't saw
5/11.
nobody. I didn't saw nobody.
And that
Hold
ticket
on.
has
She's
I did
speaking.
not saw nobody. I had an argument with him.
Did you hear what I just said? I
I
said,
had an
do not,
argument with him.
Mr. Lewis, do not speak when the state is speaking. I need to hear what she's saying clearly. All right, so go ahead.
Stop
So
lying.
in order for that ticket to be upheld, he had to be cleared by mental health, which he was. And so he was cleared by mental health and is now in SEG, as evidenced by the color of his jumpsuit that he's wearing today. The state has attempted to work with Mr. Lewis for several years, and Mr. Lewis has been unsuccessful when placed in the community, even in a less restrictive setting than prison.
I said the deal, Mr. Brewer.
Mr. Lewis, I told you, do not speak. I expect that you would
She's
listen.
lying all the time now.
On 5 separate occasions, a judge has found Mr. Lewis to be a danger to himself or others, hence his involuntary placements to Connecticut Valley Hospital and or Whiting. And obviously the judge knew what they were doing because each time he has created new victims upon his release. There were several other assaults while he was under the jurisdiction of CVH that weren't presented in any of his violation reports because people didn't want to press charges. And so those didn't go, those didn't get reported in the PCS violation reports. I'm not quite sure what else we can do for Mr. Lewis. We're requesting a full revocation of his parole as a result of his continued non-compliance when he is in the community, even in a setting that's supposed to be therapeutic and helpful. He creates chaos. He creates chaos when he's in the most appropriate milieu for him. He's got a history of assaultive behavior in the community and in the correctional institution, not just at CVH or Whiting. And his violence has progressed significantly over the years, even while under supervision. And he's caused severe bodily injury to other people, hence why he continues to get committed to the hospital. And Parole and Community Services has exhausted all the resources that we have at our disposal and still can't help Mr. Lewis be successful in the community. So we really would like to see a full revocation.
Okay.
I don't know what the hell you said.
All right, so turn it over to council now.
On behalf of Mr. Lewis, if I may just add, he did just say 14, 15 months, whatever the case may be. He's still being held on that particular one. He disposed of this new matter, which occurred prior to the other incident with a 9-month sentence, and he's going to max out on September 18th because of the previous remand. He can't be released regardless of what DOC decides to do with him. He's 34 years old, as indicated by he is at Whiting Forensic Hospital. He reported to us he did complete the 11th grade at ACES Whitney Academy in Hamden. It's a therapeutic school that he was put in there to DCF. Does receive disability for mental health purposes since the age of 16. He did report to us he did receive clinical care, including weekly individual therapy at Whiting Forensic. and also participated in some NA meetings. He also did report to us, actually reported to me. I did speak to him last week. He is working in the kitchen, was working in the kitchen at the facility, passing out food trays 7 days a week. He worked in the morning, and he
Not
reported
anymore.
to us he is meeting with a mental health counselor twice a month. He does want to obtain a GED, does aspire to attend culinary school, and is also interested in learning how to fix automobiles. Thank you.
Thank you. So I had reviewed all the evidence provided by the state. I've listened to testimony today. I will put on the record, the offender has been incarcerated since 10/24/24 on the previous violation, was served the warrant on February 21st, 2025 for this new conviction that he received for assault third, and did receive that 9-month jail sentence. There are, I have 4 previous violations on this period of special parole. I have noted what was said by the parole officer today. Based on all this information that I have and testimony that was provided, which includes the history of violence as well as the currently being in seg for assault. I'm going to recommend that parole be revoked and that offender be reparoled from May 20th of 2026. This is about a 15-month period confinement as a sanction. Offender will have, I believe, 7 months remaining on special parole left to hopefully be placed somewhere before he's off of special parole. I also recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, mental health treatment, medication compliance, behavior management program for anger management, no contact with victim GHOBMB, general no contact in New Britain, Connecticut. My findings will go on the parole board on May 22nd. Everyone will receive, well, the decision will be made that day, which can be, there can't be any sooner than the previous date that was stated, which I believe, what day was it?
I have it's 1/2/26.
1/2/26 would be the earliest.
Right.
So so it can be longer, obviously. Mr. Lewis, you'll know the decision on May 22nd, what the parole board's decision is. And you'll get it in.
Why, can I tell now, why y'all give me 15
No,
months
we're
when
all
I'm gonna
set.
do?
We're all
Why
set.
y'all give me 15 months when y'all give me 14
You're gonna
months?
get
Why
it in
y'all
writing.
give me 15? Why do y'all give me 15 months when y'all give me 14? When I'm gonna give me 14?
Mr. Lewis, the hearing is done. We're all set. Thank you.
No, I mean, I'm gonna go to court with y'all.
You'll
I'm
get
gonna
it in
sue y'all.
writing.
I'm gonna sue y'all. I'm gonna sue y'all.
Thank you.
Remember that. I'm gonna sue y'all. You bitch.
Hey,
Thank you, Feel Goodman.
thank you guys.
I appreciate your testimony.
No, I appreciate it. I just don't know what do we
I
do
know.
with him?
I know. I understand completely.
It's the prison's the only thing that can contain him. Bye, guys.
Yeah.
See you later.
And that hot mic says it all. It says what we are all thinking, what we all know. He needs to be locked up. Well, we're about to see a hearing, something that we don't see very often. As a matter of fact, this might be the first time that we are seeing it, and it is a supplemental hearing. So basically, the parole interviewer went to the parole board and said, hey, I want to sanction him for this period of time. And the parole board, or panel of 4, said no.
Good morning, hearing examiner and vice chair. Today is May 22nd, 2025. And the board members, please state your names for the record.
Jennifer Tenney, Joy Chance, Deborah Smith Palmieri.
This is a final revocation due for Louis Marlin, number 379405. Recommended a revoke with a repro date of 5/20/2026 with the following conditions: halfway house placement, no consumption of alcoholic beverages, mental health treatment, medication compliance, behavior management program for anger management, no contact with victim GHOBMB, general no contact with the British Connecticut. Board accepts or rejects recommendation.
I have some serious concerns. With this case, Mr. Lewis has really struggled with, parole supervision and give people a hard time. I think in this case, it might be important to talk to him, but let's see what your thoughts are. Ms. Chance?
So I guess the idea of a conversation I would go along with. You know, I wanted it to the US to expect a parole every, but would be willing to speak with him to find out what's been going on with him.
Ms. Palmieri?
I don't disagree with anything that's been said. I did believe, in my view, that the sanction was appropriate. And the remaining time that he'd be left on special parole would benefit him, especially in light of all his mental health needs. Some supervision to kind of get him going, but I do think that the behavior is concerning, troubling, and ongoing. I do think that the sanction was appropriate.
And the field is pretty adamant that they've tried everything to work with him and he's just not workable and, you know, he's had involuntary commitments, they have not worked out.
And now the big question sign for them is there's nothing more for them to do.
Right.
No, I mean, the remaining time that he has on supervision isn't going to give them a lot of time to really do much with them other than
Exactly.
put in, you know, get him.
The problem is his violent behavior,
Mhm.
right? So, you know, it's not, some might say he's where he belongs in order to keep the public safe at this point.
Mhm.
Okay, all right. In the matter of Marlon Lewis, 379-405, I'll make a motion to reject the recommendation of the hearing examiner and bring this case forward for a supplemental hearing. Is there a second?
Second.
All in favor?
Aye. This is for Lewis Marlon, number 379-405.
Do we need to say when the supplemental will be?
It's on here, but I don't know if it necessarily has to be stated.
Okay. Okay.
We can schedule him.
Thank you.
So there it is, something that we've never seen before. They got the recommendation from the parole board interview and they're looking at their paper and they're like, yeah, this doesn't look right. Let's meet with him in person. So we're about to see this hearing and I got to tell you, it's mind blowing. And I just want to point out as well, before we jump into the hearing, that the reason I haven't included the classic no parole for Tate or Lindsay is because I think that this hearing is just a little bit more serious than the rest. It's my opinion. I believe that this man is a ticking time bomb, that he will kill. And that I don't want to leave any room for those who will see this in the future to I guess put this down, to put this process down. I think that what we are doing here by tracking all of these hearings over the course of more than a year, thanks to Sir Richard and Lady Holly's spreadsheet that makes it possible to do this, I think it's really important to see just how the system continues to fail. Now, it's not as if there's a lack of effort. It's not as if the systems and tools aren't in place. I think it's simply put is that some people are meant to be locked up. Some people cannot be held anywhere but prison. And I think this man certainly is the case for that. But with that, let's jump in.
You hear me okay though?
I hear you.
Okay, so if you're asked anything, you might just speak up, okay? So we can hear you.
Okay.
Yeah, he can hear us fine.
It's just,
It's not.
That's the other way around.
okay, we're gonna get started. Good morning, my name is Professor Meisinger. Today is May 29th, 2025. I'm a hearing examiner for the Connecticut Board of Pardons and Paroles. This is a supplemental hearing for Lewis Marlon, number 379-405. This is a public hearing, public access. This hearing is available via video live stream. Can the board members please state your names for the record?
Good morning, I'm Jennifer Zaccanini.
Deborah Smith Palmieri.
Joy Chance.
This hearing is being conducted because a panel of board members have identified issues that may justify confinement beyond what I recommended at the board review, May 22nd, 2025. Mr. Lewis, can you please state your name and number for the record?
My name is Marlon Lewis, 379-405.
Thank you. Ambulance of Attorney, Sirica present, can you please, identify yourself?
Sure. Attorney Alfonso Sirica, public defender with the Parole Revocation Unit, on behalf of Mr. Lewis.
Hang up and quick rejoin us and could resolve it.
Okay, let's try to resolve it. All right, so hold on one second, Mr. Lewis. We're gonna try to restart so we can just hear you a little better.
Are you an F or a PH? I should know. Thank you.
SIRICA.
Mr. Lewis, can you just say something so we can check if we can hear you?
Can you hear me?
Yes,
Perfect.
That's better.
thank you, Kristen.
Just have to push the number 1 to adjust number 1.
So we are now back on the record. So you have certain rights that apply at this supplemental hearing. You have the right to receive written notice of this supplemental hearing. Did you receive a packet of information which includes the written notice for this supplemental hearing, hearing summary and reason for the supplemental hearing? Did you receive the information?
Yes.
You have a right to be represented by an attorney at the supplemental hearing. You may hire your own attorney, can't afford attorney, you may qualify for an important attorney. You have an attorney here today. You have a right to submit relevant documentary evidence addressing only the issue or issues that the panel determined may justify confinement beyond what I recommended following your revocation hearing. Do you have any relevant documentary evidence to submit?
I will be speaking to that on his behalf.
You have a right to call witnesses to testify on your behalf and or cross-examine diverse witnesses regarding only the issue or issues the panel determined may justify confinement beyond what I recommended following your revocation hearing. Today we have no witnesses. Will you be calling any witnesses to testify?
No.
Do you have any questions before we begin?
No.
So I found that you violated the following conditions of parole, obedience to the law. I recommended revoke and re-parole for May 20th, 2026, an approximate 15-month sanction. The panel determined that the following information can justify a longer period of incarceration. The board decision was due to the violent nature of Mr. Lewis's arrest and his violent history. Mr. Lewis's assaultive behavior, both in the community and in a correctional institution, has continued throughout this period of supervision. So this is your opportunity to respond to these concerns, if you'd like to.
Yes, if I may, on behalf of Mr. Lewis, I'm not sure what documents the board reviews at the revocation reviews regarding the last incident. There were 2 incidents that were a day apart. October 22nd of 2024 is the incident I represented Mr. Lewis on, and there was an incident on October 23rd of 2024. The October 23rd, 2024 incident, I did not represent him on that. He was brought in front of a hearing examiner on that particular incident under an obedience to the law charge, and he was given a 15-month sanction for reasons unknown. My case, that warrant was an older warrant, an incident that happened the day before, and that was brought forward after he was already sanctioned to the 15-month. And typically, as I indicated, I've been with our unit from day one, approximately 6 years. When incidents a day apart, typically brought in front of the hearing examiner simultaneously because for some reason that warrant was not signed. I'm not making any claim that this was the 2 distinct incidents. I will concede to that. So I go for the October 22nd, 2024, and I represented Mr. Lewis, and I was already stuck with the January re-parole date, and the way I'm doing the math, the hearing examiner did add additional time, because the new re-parole date was January of 2026, and she gave him a new re-parole date of May. So there was an additional plus 4 months, in my opinion, that was already given. I understand what the purpose of a supplemental hearing is also. As far as those incidents regarding its history, and once again, with all due respect to the board, I'm not sure what the board reviews prior to rejecting that recommendation. My client was civilly committed in April of 2024, and I do have the document. It indicated that there were 2 physicians at this probate hearing, at least one of whom is a practicing psychiatrist, and he was civilly committed by Judge Stephen Boa Demora, Demoura. So, and the reason why I'm bringing that up, because along my representation of Mr. Lewis, everyone keeps saying, there's nothing we can do for him. He belongs in jail. I'm not sure the supervising officer report, I'm not sure what documents are reviewed, but it's important to note that also my client has been involved with DCF since the age of 15. He does have a diagnosis of schizoaffective and bipolar.
Do you want to, I'm sorry, attorney, do you want to go into executive session to discuss this mental health?
You don't,
you're fine.
I don't, but it's public information.
Okay.
As far as we are concerned. And I was able, we've been having a hard time with you, even though we signed releases, regarding, his current status.
Mhm.
So this just came this morning. This is from the APRN at the facility, Miss ANOP, which is a licensed clinical social worker of the Department of Corrections, who's been involved with Mr. Lewis for a while. I have a good report, and he is respectful during all our interactions. He does engage in once a week individual therapy sessions. He's appropriately placed on a lower functioning block, as I indicated. His IQ in speaking to him, part of the issue with him acting up is people make fun of my client. I understand, he's a bigger individual. He needs to control his anger. I've discussed that with him, but DOC does have him in the proper block. So I indicated the two diagnoses of the medical terms, the schizoaffective and bipolar. And I quote, he is 100% compliant with his medication. He's not paneled and takes them voluntarily. He's on treatment, and also FLUPHENIZINE. I can't pronounce that word. It's an antipsychotic medicine. So he's currently 100% medication compliant. He is taking advantage of the mental health treatment in the facility. Yes, and he's been receiving SSI for his intellectual disabilities since very young age. So I understand the board is concerned regarding his behavior. It's concerning to all of us. But once again, I'm not sure what documents reviewed. He was given, in my opinion, an additional 4-month sanction. I'd like to have him get out the May date, so there's some services in place for him, because it's only roughly, I believe my math is correct, it's about a 7-month span that's left. And given his entire history regarding the DCF involvement, the civil commitment in probate court, the 2 diagnoses by medical people, he is currently medication compliant. To have him go back out in the community with nothing in place, I think we're going backwards, in my humble opinion. So I just wanted to bring that to the board members regarding, increasing the sanction. Thank you.
I'll turn over this report.
All right. So I'm interested in knowing, Mr. Lewis, our concerns, your violent behavior, right? You had a fight with another resident, you received a new conviction, and then you come back into DOC and you have an assault ticket just this month. So I want to know why you acted out in this way and what we're going to do in the future to control your behavior so nobody gets hurt.
Okay. Well, the fight I had in the DOC, it wasn't really a fight. They said I throw the chair at the person, but we was having an argument in the cell, and he called the CEO, and then we ended up with the SAG, and then I guess he lied and said I had a fight with him, so I could lose my job.
Well, it's not a fighting ticket. I just want to clarify that. It's an assault ticket.
That's what I'm saying. I didn't assault him.
So you're denying that you assaulted him
Yeah,
at all? Nothing, according to you, nothing happened.
nothing that happened. We had an argument.
Generally, they don't give you assault tickets without proof, without any type of evidence.
They don't got no evidence because it was in the cell. They said I threw the chair at him. I didn't throw no chair at him.
Okay, what about what about the assault when you were at Whiting?
So when I was at Whiting, I was under the influence of Depakote, and I had a side effects, and I couldn't sleep, and I had a lot of seeing things, hearing things, and a lot of anxiety. So the fight what happened, which fight was that? Which one was that?
You're beating up another resident while he was on the floor.
Is it the one in the courtyard or the one in the hospital?
Oh, yeah, both.
Oh, okay, well, they was picking on me. They called me name and he threw the ball at me. He threw the ball at me and it hit me in my stomach. So I ended up got mad and I hit him.
But you can't do that, sir.
I understand, but he the one instigating that he got in trouble as well. He got in trouble for instigating the fight. You know what I'm saying?
I understand what you're saying, but if I assaulted everyone who got on my nerves, said something that I didn't like, then I'd be in prison with you. We can't, that's not how we react.
I understand, but I made a bad decision and I was under Depakote and I was on a lot of medication what wasn't helping me. So that's why I couldn't make a smart decision.
Okay, so have you done any programming? Have you addressed?
I didn't do any
better decisions. Go ahead.
I didn't do any program, but I was talking to my mental health. I was talking to my social worker about how can I progress with my anger and all of that, and my mood. She was helping me out, and I set some goals about how can I change my mood state, my mood around. And I was telling her so I like to like read, watch TV, or talk to somebody if I have an issue. Like go to a staff or go to a mental health lady and talk to them and be like, oh, I have an issue with this person. Me and him is not getting along. Can you please somehow help me out in the future? So we won't end up getting a conflict with any emotions and stuff like that. So she let me know. Said that's a good answer. She said that's a good selection because you really do have to talk to somebody before you react with somebody. You know what I'm saying? So that's what I want to do. I want to end up talking to people instead of using my own anger on somebody. I'd rather talk to somebody and have them help me out in a situation that I don't want to put myself in trouble.
You've had a lot of difficulties on parole supervision. Is it all because of your anger?
That's not all because of my anger. Well, I wasn't seeing parole when I was in the community. I used to take off because I have a drug history. And when I go out there in the community, I be like paranoid. I be a lot of paranoia and all that. So I just need supervision. You know what I mean? Have some kind of supervision, and so I can progress in the community.
But you understand, you're not going to have supervision forever. There will come a time.
I understand that. Once I get off of special parole, I should be leaving the country, going back to London.
Okay, so what is the plan? For where are you going to live? If you go back out on parole, what's the plan?
He's got to be obviously finished. If hopefully he gets back out. He's going to be here. He's got to be placed in a halfway house. As far as here, if I may, chairperson,
yeah.
He did put it on the record. Part of the email I did receive this morning. There is a treatment plan. Is basically what he said. They do have goals, self-management for his mental health symptoms by utilizing coping skills, self-awareness of mental health diagnoses without acting up. So there are steps. I do have the letter from the APR, and they do have a plan in place. I might neglected to put the second part of the email on the record. But Mr. Lewis, I believe, put what I already have on paper. If I might just have one moment regarding your other question. Yeah, he's whatever his field officer wants to play. He can't leave it. And he's mentioned in London, his father lives there, and he's visited there kind of been back and forth in the past, but he does have his dad who lives in London. I think the plan is to get him back with his father, obviously after he completes his period of supervision.
I don't have a father. My father's dead.
Backed away now, but that's what we had as far as you have family members in London, correct?
Yeah, but my father's dead. But I have I have brothers and uncles.
Okay. In London.
Yes.
Okay.
But you know, you haven't had much success, like in a halfway house. There's a good chance that someone might rub you the wrong way, maybe make fun of you.
Well, I have some, like I said, I'm working on some goals right now, talking to a staff or talking to a member, a friend, or anybody that can stop the situation of me getting into a fight or getting into somebody's face to hurt them. So that's what I'm doing at this moment. I've been working on the time. I've been locked up in jail, and plus I've been working on it with the social worker, and she said I'm doing very good because I had a couple of situations with people in there,
right?
And like you said, like that incident when I had with the person said I assaulted him, I didn't really assault. I had an argument with him, and I don't know why they said I threw the chair at him. I guess the CO probably I had a chair, but I didn't hit him with the chair. I had a chair in my hand. But I put the chair down when he said, get down and go in your bunk. I put the chair down, and I guess the other guy got arrested, and then I got arrested. Then they said I assaulted him. I'm like, no, I didn't assaulted him. But
what was the argument about, sir?
The argument was about because I was watching TV, and I guess I was bothering him when he was sleeping. I guess I was yelling or.
You have a TV in your cell?
Yeah, I had a TV, yeah.
Do you have a cellmate now?
No. Yeah, I have a cellmate. Yeah, I have a cellmate.
Say that again?
Yes, I have a cellmate.
You have a cellmate right now?
Yeah.
Okay, it's somebody different?
I lost the TV. It wasn't my TV. It wasn't my TV. I lost the TV. It was somebody that gave me the TV to use.
Yeah.
But yeah, I lost the TV.
How long have you been with your current cellmate?
About 3 weeks.
Oh, since the ticket. Okay, and you haven't had any issues, no arguments?
No issues, no argument. We're getting along. He's leaving the block. He's leaving the block pretty soon. In 2 weeks, he's leaving the block, and he's leaving the prison. He's leaving DOC to a different jail, a higher functional jail. Me and him haven't had no conflict, no nothing. We share each other. We talk to each other.
Yeah. Okay.
He all wish me good luck in my hearing. He wished me good luck. He said good luck to you. You know what I mean? We're getting along.
Okay.
That's good to hear. So when you picked up the chair, why did you pick up the chair?
Well, he got in my face. The little guy got in my face, started saying, you know what I mean? He got in my face, started yelling at me. So I picked up the chair and I said, back the up. And he was like, I'm not scared of you. So the CO got up and said, Marlon Lewis, sit down in your bunk right now. So I put the chair down, I sit down in my bunk, and then he said, you stay right there. And then they popped the door and they arrested him, and they arrested me afterwards.
Okay.
And that was it.
Okay, let me ask you one more question, Mr. Lewis. So you will need to go to a halfway house of some type, right? But you've got a couple of violations where you cut the GPS off, you walked away from the halfway house, you weren't going to treatment while you're in the community. Why will it be different this time?
Well, it's going to be different because I'm going to be working with Capital Region, and I'm going to be working with my pro officer, whoever is my pro officer, I'm going to be working with them, and I'm going to try not using drugs. Try not to stay away from drugs. I know it's going to be hard for me, but I'm going to try my best because that's another goal I've been working on too, is staying away from the drugs. And now I have so short left on special parole, I can just stay away from the drugs, get off, then fly to London and get supervisions with my family that can help me out in the future to like become a more successful person. So that's what I'm trying to do. I'm trying to just, whatever is left on special parole, I want to do good for myself. Whatever is left on, I want to do good, and I want to get treatment, and I want to have a counselor I can see in Capital Region every once a week to talk to about my mood, and I want to go to NA program about drugs and narcotics.
Okay. Well, I did read that you were supposed to be going to Capital Regional when you were in the community, but that's one of the places that you stopped going to. So why do you think parole will be helpful?
Why do you think a parole would be helpful for me?
Yeah, why will it be helpful to you?
Because they got like treatment, they got like places you can go to that can help you. I heard they got a lot of like places like groups, NA, stuff like that, where it can help me in the community to change my life around and make better decisions and walk a straight path. So that's what I'm trying to do. I'm trying to get in those groups. Once I get in those groups, then I can just start achieving.
But if you wanted to do good in the community, you could go to those groups all on your own.
That's what I'm trying to do. I'm trying to go on my own, but I don't know how to get there. So I need a little counseling from a person that can set the appointment up. Let me go there. You know what I'm saying? Set the appointment. I don't know where to go at for help. So if I have a parole officer, which I have, she can set up those appointments for me to go to, and I have Capital Region too that can help me out too. So that can keep my mind motivated. So the rest of the time on special parole, I can be completing my process of getting done with special parole. So y'all won't be like, oh, this guy is not progressing. He just, every time we let him out, he's doing something negative, or he's running away from special parole, coming back to jail. We don't want this from this guy. We can't trust him no more. So that's what I'm trying to just put my foot down and be like, it's time to change this whole thing I've been doing and become better at what I've been doing in the future, in the past, do good in the future, and forget the past I've been doing, and to keep on progressing like I was doing in jail.
Okay, Mr. Lewis. Well, everybody wants you to do better in the community, to progress and be able to live, because, parole, it's been there this is the fourth time now that parole has had to bring you back because you don't want to work with parole.
Yeah, I want to work with them, and just me making stupid decisions and using drugs. I'm a drug addict. I'm not gonna lie. I use crack, and I don't want to use that for the rest of my life, because right now they putting stuff on the drug that can kill you. So I want to stay away from the streets, stay away from the negativity, and live my life and become somebody responsible, somebody trustworthy, and somebody who can, somebody who can just take care of myself in the right way, use coping skills and all that stuff, so I can just become a successful person. And I want to use those coping skills. I want to use my coping skills, and I want to go to NA, and I like to go to Capital Region and then talk about my medications to a doctor and see how I'm doing in the community.
Okay, Mr. Lewis, thank you.
Yeah.
Mr. Lewis, you mentioned your parole officer. Typically, you go back to the parole officer you had before, and you weren't very nice to her.
Who, you mean Kim Goodman?
Yeah.
I've been kind of, you know what I mean, in the mean.
You were mean to her. In fact, I heard you on a live stream when you were sober and a clean mind. You called her a dumb bitch on a live stream for the whole world to hear.
I'm gonna sue you. Remember that. I'm gonna sue you. You bitch.
Hey,
I know, I'm so sorry about that. I like to apologize to her, and I hope she can accept my apology. I was just going through a lot, you know what I mean? I was going through a lot.
Right, but that doesn't give you a right to abuse people.
I understand. I should have did that.
And you do know a parole officer's job is to help you. That's their job, their only job. They're not trying to hurt you. You hurt yourself by getting convicted of an assault.
I understand.
You understand that?
I like to apologize to her and make it up to her by doing the right thing.
And the
you know
doctor too. You mentioned you want to go back and see the doctor, but we read that Dr. Berger, you spit on. That's not the way you treat people who are trying to help you.
I understand.
It's her fault, yeah. I mean, you have to control your anger.
I will this time around. This time around, if I do have a chance, I'm gonna change my life around, because I can't put up with myself coming back here and not having no one to believe in me, you know what I mean? And I want people to believe in me, that I can change and become a better person, so I can live my life successful. So I just want those beliefs to come true. So this time I'm gonna put my foot down and I'm gonna do the right thing and make people happy and make myself happy in the long run.
All right, Ms. Chance?
Yes, Mr. Lewis, you know, one of the complaints that you have is that people call you names.
Yeah.
So rather than hit them or assault them, what would you do? If someone came up and called you.
I like to step away from that person, take a walk, or ignore the person, go to my room, do something different, probably take up a book, read it, or read the Bible, or talk to somebody and tell the person, talk to staff, tell the staff, and if there's no staff around, talk to a friend. Talk to a friend, or go to your room and listen to the music. So,
Mr. Lewis, you're saying all of these things, but you shouldn't only say it, you should make sure when you say it, you mean it, so that when it happens, you don't assault someone again.
I won't assault nobody. I promise you all of my life I have left of me, I'm not gonna assault nobody no more, because I was in the wrong, you know what I mean? And I don't like to put my hands on people and hurt them. You know what I'm saying? I'd rather talk to them and become their friend, or apologize, or we make up and we see each other in the right foot. You know what I mean? I don't want to just put my hands on somebody and think that's the best way to get across that situation and all that. I'd rather talk to them and become a friend member, or a guidance, or a role model. I like to be a role model.
On that note, where is your grandfather?
My grandfather, he's in East Hartford.
Okay, so is he a support for you, or why did he throw you out? What happened?
Well, I was taking my medication and all that, and I told the nurse to go downstairs and give me my medication. I guess he got mad and said, "David, take your medication upstairs. I want to see you take your medication in front of me." So I was like, the nurse, that's what the nurse's job. The nurse can see if I take my medication or not. So I guess he got mad and he said, "You know what? You gotta get out of my house." So I got kind of, you know what I mean? We had a misunderstanding. But next time around, if anything do happen and I'm in somebody's house, I'm gonna listen to that person, all the rules he set down in the house, I'm gonna listen to him, and I'm not gonna say if or but or maybe, I'm just gonna do it. Whatever he tells me to
Okay,
do, I'm
so
gonna do
Mr.
it.
Lewis, the issue is that you are not taking the meds, and so the nurse had to come to tell you. And your grandfather was concerned that you're living there, you need to take your medication.
That wasn't it. I told the nurse to come downstairs and give me my medication because I wasn't feeling well. I was laying on the bed and I wasn't feeling well, and I was so tired, and I didn't want to get up in the kitchen to take my medication. So I said, grandfather, tell the nurse to give me my medication downstairs, that I was sleeping in the basement. And he said, no, take your medication upstairs right now.
Okay, so my other concern is when you go back in the community. Now, your father, who you were going to originally go to, died. Are you in contact with your brothers and your uncle in England?
I talked to my brother a long time ago, and I heard he had just had a daughter. He just had a daughter. His name was. I haven't talked to him for a minute. I haven't talked to my uncle either, but I have conversation with my uncle at Sunsplash. I have a relationship with my uncle at Sunsplash. He has those numbers I can contact and see what's going on in the other side of the world and all that, so I can see what's up if they want to take me or not. If I have any hope or anything.
Right, so that's the concern, Mr. Lewis. You do have relatives in England.
Yeah.
And we're not sure whether they're going to be amenable to having you come and live with them. In the meantime, you're going to be here out in the community at a halfway house, and you have a grandfather here that you were once living with.
Yes.
So I think it would behoove you to try and find out what your relationship with your grandfather, because you have no other support here.
He don't have, I'm sorry to cut you off. He's very old. He's like in his 90s.
Okay, so you are assigned to go to Capital Region. The other question I want to ask you, when you go there, do they assign a case manager to you?
Yes, they do. Yes, they do.
So that case manager is the person that's supposed to help you go to your appointments, make sure you have your proper medication, and that you are, following the rules of your parole officer. So you have to also be kind to that person and listen to that case manager.
I will do the best I can, and I'm not gonna disrespect them or call them names. I'm gonna be on the best behavior I can, because I don't want to mess up this chance of me going home and coming right back. You know what I mean? Y'all guys are working so hard to get me out of here and let me be on the right foot and all that. I don't want to mess it up no more. I'm tired of coming back to jail and doing the negativities and y'all believing I'm a bad person. You know what I mean?
Okay. So my last question is, you mentioned that you are going to try not to use drugs. So what happens when you get an urge to use some crack cocaine? What do you do at that particular moment?
Let's see. I have some goals about that too. Well, I'm probably go on the phone, talk to my mom or my brother, what's in America. His name is Jermaine. Talk to my brother, be like, yo, Jermaine, or my mom. I tell my mom, like, Mom, I'm thinking about using. I don't want to do it. What should I do? Or talk to a staff member. Talk to somebody. But I don't want to. I want that like a case manager. I'll talk to my case manager, or I talk to my parole officer, and see what she says about it. I want to talk to somebody before I use, because once I go out there on the streets and use, I don't show up for special parole, I'm coming right back. And I don't want that for myself. I want to make the best decision. So I could be out there in the community getting the help I need. I can't get help in here. I can't get no help in here. It might be a little help in here, but it's not that much help. In the community, I can get the best treatment out there.
Have you ever attended NA or AA meetings?
I used to back in the days when I was in DCF custody, when I used to smoke weed, I used to go to NA meetings. We used to talk about substance abuse. We used to talk about.
Did you find them helpful?
That was very helpful, very helpful.
So then you should think about going to a meeting or two a week, okay?
Yeah, I will do that. I will go to NA. I'm gonna talk to Capital Region and see if they can put me into a group, because they have programs out there in Capital Region and Hartford that I need to go to. I need to go to those kind of groups so I can change my whole mood around. You know what I mean? Change my life around.
Okay. Thank you, Mr. Lewis, for answering my questions.
Yes, ma'am.
Officer Meister, can I just clarify with you? Did you recommend a 17-month sanction?
15.
From the date he was served. 15.
From the date he was served.
Because he returned in October, right? Yes, and then, but then when he was served with the warrant, that's considered the date that I look at starting. Okay. As for return, but he's remaining in custody. But so from that new date that he was served the arrest warrant, I gave him 15 months. Okay.
Got it. I understand you did. His new re-parole date was January.
It ends up being an additional 4 months because that's how many months it took from the day he was served.
Okay.
Yeah. And can you please tell me again what your recommended conditions were? I have conditions here. I just want to make sure they're right. Halfway house placement, no consumption of alcoholic beverages, mental health treatment, medication compliance, behavior management program for anger management, no contact with victim GHOBMB, and general no contact with 263. We're going to discuss your case. Just listen, okay? Please don't interrupt us, and we'll give you our decision shortly, okay?
Yes, ma'am.
All right. So here's where I stand. Mr. Lewis has had challenges, of course, under supervision, and during incarceration. He has been back for 7 months now, and he has that one ticket which he explained to us. More importantly, he needs help. He does need help. I think he does have some insights today. He has expressed remorse for his actions and recognizes that he has a problem with anger. I'm happy to hear from his attorney, and he is working with someone in the facility and appears to be compliant with treatment at this time. With all that considered, I would be willing to re-parole him on this period of special parole, so he has some supervision and support. And it's a short period of time, but something to get him started before his special parole ends. Thoughts?
I agree with everything you've said. I also heard today from Mr. Lewis, that he has some coping skills, at least that he's been trying to implement, that he'll be able to use in the community. I think, he seems to know what he needs to do. He just needs to follow through, and he wants the support of parole, but he needs to utilize it appropriately. As you pointed out, he's not been very cooperative with the parole officer in the past. I think, the remaining time on special parole, will give him enough time to get help him get those appointments that he says parole, he's hoping parole will help him. Yeah. But then he's on his own. He knows what he needs to do. Has had a lot of contact with Capital Regional. He knows how to get there, and they know him. So, parole should just be kind of we'll only stepping stone. Yeah.
Okay. Thank you. Ms. Chance?
Yes, I do agree. And he did acknowledge that he understands the needs for a case manager.
Mm-hmm.
And Capital Region should be doing that to appoint someone with him, because I did hear him say, in terms of all the appointments and the places that he has to go, that he has problems going there. And I can see sometimes that would be a frustration for him. It's important for him to work with that case manager that Capital Region will assign to him, because that should be part of the treatment plan that they have there for him. If he works with that case manager along with parole, even after parole ends, he will have that case manager. And that's important to help him to, stay on track and try to reconnect with his brother or his grandfather or his relatives in England. And I think that piece of it is very, very important for him, because I think he just wants to know.
Are you
that
in
he
agreement
has
with the
done
referral?
it there. Yes,
Okay.
absolutely.
Mr. Lewis, you understand that if we give you a new date and you get more tickets, you lose that date. Do you understand that?
Yes, ma'am, I understand.
You really have to
I'm gonna
try
be on the best
hard.
behavior. I'm gonna be on my
Yes.
best behavior.
Be
and
kind to
approve.
people and if you have to ignore people, then that's what you do.
That's what I'm
All
gonna
right.
do.
Okay, in the matter of Marlon Lewis, inmate number 379405, I'll make a motion to revoke special parole and re-parole on May 20th, 2026 with the following conditions: no consumption of alcohol, halfway house placement, no contact with victims, OB, MB, GH, general no contact with 2 New Britain, mental health treatment with medication compliance, and an anger management program in the community. So that was the hearing examiner's original recommendation. Is there a second?
Second.
All in favor?
Aye.
Aye.
Thank you.
All right, sir, we wish you the best.
When do
Go
I
do
leave?
good.
When do I leave? May 20th?
Yep.
Yes.
Marlon, I'll set up a call with you next week. I have hearings today and tomorrow. I'll get a call with your counsel next week.
You know what
I'll explain.
house I'm going to?
No,
No, not yet. I'll call you next week, okay?
All right.
All right.
All right,
Thank
this
you.
concludes the supplemental hearing for Lewis Marlon, number 37905.
They end up not adding more time. They end up saying, "Oh, he's a good boy. He needs to go to his family in England." It's like out of a comedy movie skit. It's like, what? England? What? Oh, it's so important to him that he rekindle his relationship. It's like it only takes one Google search or drop it into your favorite chat AI thing to find out that England will not take felons into their country. He won't be allowed into that country. Like all of a sudden, it's so important to rekindle. It's the first time we hear about the narcotics. So he knew exactly what to say. He knew just what to say. He is playing the system like a fiddle. He knows what he can get out of it, what buttons to push, when to push too far, and it's insane. I cannot believe that the parole board, with all the information that they have at their behest, was seeing that every time he got out into the community, he created more victims, and their biggest concern was that he called the parole interviewer the B word in front of the whole world to see. That was it. Not that he created new victims, not that he violently assaulted his roommates, not that he spit blood into the doctor's face. That alone should give a man years of prison. It's like madness. And I am so happy again that we're able to cover this. This was spanning over. This is a lot of work. I might be wearing this. This is a lot of work. You heard the recording quality wasn't good at sometimes, and I had a background because I'm in a new studio, and I'm Sir Richard and Lady Holly's spreadsheet spanning the course of over a year. And by the way, I do believe we will see him again soon. There is another way that we will see him before his special parole day, and that would be what's called a rescission hearing. And a rescission hearing would mean that if he gets enough write-ups or something so bad that he commits in prison, that they will then have a special hearing to rescind the parole that they granted him. So it is possible that we will see him again in the next 6 months or so. But they wanted to make some excuse to say, oh, you know what? We need to give him some more special parole. Let's let him out again in like a year. Like all of a sudden he's going to be better. And it seems they're letting him out to a halfway house because he has a restraining order from I think the medical facility that they've been sending him to, is my understanding. They just kicked the ball down the road. That's all they did, was kick the ball down the road. And it's just so eerily similar to the horrific case that I spoke about earlier. It's so similar. It almost seems like it can be the same case. You know, let me go read some similarities. If this maybe this rings a bell. Again, I'm talking about Brown, who murdered Irina Zarutska in the train. We all know what we're talking about, right? Unless you've been living under a rock. And what just sticks out to me about this case is that I see everybody in the news and and all over Twitter, all of a sudden, how could this happen? How could this happen? Our week on crime. And meanwhile, for years, we're showing the world, we're broadcasting exactly how it happens, but the algorithms suppress us, or we're not grifters enough. I should be a better grifter. I should get up on Twitter and do all the grifting, right? But no, we talk about it, we publish it, relevant story after relevant story. And I just, again, needed to bring it up again. We are seeing Connecticut do this. I believe this man will get out and kill someone. And it's just crazy because with all the information that we just saw, the parole board in their wisdom said, wait a minute, we should give him a longer sentence. And then somehow they get fooled. By his like, oh yeah, I'm going to, and they're like, you need an anger management class. And he's like, yes, anger management. And it's just nuts. I mean, this here is just, anyway, so let me just continue. So, 34-year-old suspect had a criminal record, including larceny, breaking and entering charges. He also spent 5 years in prison for robbery with a dangerous weapon starting in 2015. And we can go again back to our little prince here. His record, I mean, again, Connecticut only shares 10 years. And immediately we have it. We have trespassing, we have larceny, we have resisting arrest, we have 2 escapes, we have robbery with the 2nd degree, dangerous weapon, very similar to this. Let's continue. In total, Brown has charged 14 times in the past, including an arrest in January, was still on the streets. This again was very similar. I don't know how many arrests he has. I'm counting in my little chart here. I see that I'm not even, again, this is only with the records that we have 10 years. It's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 arrests. And this is not all of them. And this is not including the most recent arrests that happened. So again, very similar. Brown's mother kicked him out of the house. His grandfather kicked him out of the house, or also something like that. Son was released from the prison 2020. Okay, this is, they talk about David. She grew increasingly concerned for the safety and of her and her husband, and took Brown to mental health hospital. She said that the hospital told her they didn't have enough room to admit Brown because he wasn't threatening to. Okay, so this is a little bit of a different issue, but we saw the problems with the hospitals and what happens in there and how it's really not meant. I mean, his PO said it very clearly. He needs to be locked up. He needs to be in prison. And they go through this hearing. They talk to him like, oh, you should take a program and you should, and you'll be okay. You should go to England. And it's putting your head in the sand. It's putting your head in the sand. Now you might argue and say, look, what's the parole board going to do ultimately? The idea is that they don't want to lock him up until he's done, because they want, when they send him out, to again have supervision so they can help put him in the right place, help protect us. Like, that's their mindset. They could have, one, I would say, lengthened his time, and 2, the problem then goes to the sentencing, to the judges, because even while out, he received 9 months for assault. And I think it's my understanding that time was running concurrent with his current time. Didn't even add to his sentence. So it was like he got a twofer. And a judge needs to give him a true sentence. All of these violent crimes, spitting blood in someone's face, in my opinion, is a violent crime. And beating people up. And even in prison, while he's waiting for this hearing, he has an assault charge on his roomie, on his cellie. You can't make that. You can't I'm speechless. I'm speechless. This man needs to be in prison, and he's going to get out, and then it's going to be on the news when he kills someone. My opinion, we don't know what's going to happen, and everyone's going to say, how did this happen? And we will point to this parole hearing, and we will say, no, duh. It is so clear as day. It is so obvious. Now, someone go fix the system. And, it starts with a light on crime. A longer sentence, a proper sentence. I don't know if he's ever spent more than 3 straight years in prison. He's gotten 3-year sentences, but he keeps getting out after just a little bit of time. And even then, if he spends 10 years and gets out, who knows? But some people need to just grow up a little bit. But this man has been playing the system, feeding off of it, getting handed free attorneys at left and right. But I thought he likes being the bully. He likes being the big fish in the little pond. He likes it. I don't, someone like this, would they really mind if they get life in prison? Oh well. Anyways, that's just my opinion.
And it wasn't, the violence didn't occur as a result of mental illness, as a result of anxiety, depression, psychosis, and that's documented in the contact notes from Dr. Berger for this assaultive behavior, but it's also documented in the revocation summaries from the previous assaultive behavior at Connecticut Valley Hospital that the violence is for secondary gain and is not a result of mental illness. No, I appreciate it. I just don't know what do we do with him?
I know. I understand completely.
So it's the prison's the only thing that can contain him. Bye, guys.
Yeah.
See you later.